The Supreme Court says Section 305 of the Constitution did not confer power on the President to temporarily dissolve executive and legislative institutions of a state during emergency rule. Alluding to the deliberate silence of the Constitution on the spirit of this Section 305 thereof, the Supreme Court added that the exercise of such powers remains subject to judicial review to prevent arbitrariness and abuse. The Apex Court, which delivered judgment in a suit by People's Democratic Party states against the declaration of a state of emergency in Rivers State by President Bola Tinubu, however, struck out the suit. Tinubu had in March, citing threat to peace in Rivers State, declared a state of emergency and subsequently suspended Governor Simi Fubara, his deputy, as well as the entire Rivers State House of Assembly members for 6 months. Let's deepen the discussion now as lawyer, activist, and indigene of Rivers State, Chetam Nwala, joins us from Port Harcourt, while our rights analyst Mahmoud Jega is in our Abuja studio. Gentlemen, you are welcome to the morning show.
Thank you.
Good morning, and thank you for having us.
Okay, very quickly. I have some arguments. One, that the Supreme Court decided to deliver judgment long after the matter had even gone off the table. The PDP governors had left. The PDP governor in Rivers had even joined. So, the thing took a long process. Why does it take our courts such a long time to deliver judgment in serious matters of constitutional interpretation? Two, this particular matter, it will seem that there is so much ambiguity. Why is it so difficult for our judges or justices, in this case, of the Supreme Court, to talk straight with clarity, conviction, and certainty, so that you have all these roadside commentators and, technicians and mechanics and laborers, interpreting and, just being generally confused about what the court is saying? And number three, what's your reading, both of you, of what the ruling, the judgment is saying? We have the bench judgment. We haven't seen the dissenting judgment of Justice Obianya, but there's so much confusion out there. Let me start with you, Chetam Nwala, and then we'll go quickly to my brother, Mahmoud Jega.
Okay, thank you, Dr. Ruben, for having me. Now, it's very important that I make certain things clear. When it comes to decisions of court taking too long, the timing, some of us have continued to raise up issues with respect to how our courts have continuously delayed delivering judgment, especially on matters of national importance. In short, as a matter of fact, 2 weeks ago, at the level of Spidel, when NBA held its Spidel in Uyo, I stated clearly, one of the interventions I made during that event was also calling on the Supreme Court that up till now, the Supreme Court has not delivered a judgment on a matter of such national importance. The same thing the NBA president, Afam Osigwe, did when he, during the Supreme Court opening of the legal hearing, he also raised up the same concern because this has become a trajectory. And there is this general balance or legal principle that justice delayed is justice denied. Because you ask the average Rivers man today, they say, what is the essence of this judgment? The judgment has today become an academic exercise, and it does not make any sense to a lot of Rivers people because we have all moved on as a state. And we are all now still reaping from the hardship that the state of emergency brought upon our states. And it's a sad situation that the Supreme Court has decided to delay this issue. But some of us are still raising up concerns and are still poking the Supreme Court. Now, if you recall, the issue that led to the earlier Supreme Court judgment that led to the dissolution of or the recognition of Martins Amehuli as Speaker, as well as the local government dissolution of local government, announcement of local government election in Rivers State, that decision from the Federal High Court down to the Supreme Court, that decision took about a year or less than 1 year. From the Federal High Court to the Court of Appeal down to the Supreme Court. Then why is the Supreme Court decision taking 9 months to come out? A matter that went to the Supreme Court of national importance took 9 months. So it simply means that there are lots of issues that are probably, waters that are probably passed under the bridge. And it's actually a sad one for our democracy and for our judiciary. Now, on the issue at hand, The Supreme Court, we had expected that. I must also state clearly that the Supreme Court judgment, or the opinion given by the Supreme Court on this particular decision, it's clear that the matter was struck out based on jurisdiction. Now, the other opinion that the Supreme Court had adduced is merely an opinion and it's not binding at any point, because they have stated that they do not have jurisdiction to delve into this particular matter, which is quite clear. Now, of course, the practice directive actually allows them to still make comments on the issues, which they have actually done. So we must also state clearly that, but this comment and this opinion given by the Supreme Court, we should not also just let it slide, because it will definitely tomorrow form part of, be persuasive on lower courts and form part of our corpus juris, as it were. Because it is still an opinion of the Supreme Court, even if in the present circumstance it is not binding, because they lack jurisdiction to even make a pronouncement on the said issue from their own judgment. So we must make this distinction and make it clear. But if you also look at the comments of the Supreme Court has further also made this whole, created more ambiguity to the issue at hand, because some of us were excited when these matters came up, that at least we would have this issue of declaration of state of emergency come to rest in this nation. So we know what the direction is. We know what should be at stake and circumstances in which such declarations should be made. But the judgment of the Supreme Court did not also settle, or the opinions expressed did not also settle that particular issue, and it's an unfortunate situation.
Chetam, we're also trying to manage time. Let's hear from Mahmoud Jega.
Thank you very much, Oga Ruben. Well, you see, unlike him, I'm not a lawyer, but because I have been reporting on politics and court cases related to politics for more than 30 years now, my main impression about yesterday's Supreme Court judgment was that the Supreme Court contradicted the letter and the spirit of the 2008 judgment that it delivered in the case of Atiku Abubakar. If you remember, in 2007, before the elections, Vice President Atiku Abubakar defected from PDP to AC. And the Obasanjo presidency declared that he had vacated his vice president seat and that his nomination as AC presidential candidate was illegal. And because of that, INEC, under Professor Iwu that time, refused to include AC on the ballot paper for the 2007 presidential election. Until 3 or 4 days to the election, the Supreme Court ordered that AC must be included on the ballot paper, and INEC rushed to South Africa and printed ballot papers without serial number, which became an issue. But a year later, in 2008, after the Obasanjo presidency had even lapsed, the Supreme Court delivered a judgment and said an elected executive officer, president, vice president, governor, or deputy governor, can only lose his seat before the end of his tenure in one of 4 ways specifically outlined in the Constitution, which is a resignation, impeachment, incapacitation, or death. And the Supreme Court ruled very memorably that nothing can be added into the Constitution which it does not specifically provide, which is why Vice President Atiku Abubakar's defection to AC, since the Constitution did not specifically say that defection was one reason in which you can lose your seat, so he didn't lose his seat. And we can say, logically, that the Constitution also didn't say that declaration of a state of emergency is one of the conditions in which an elected executive officer can lose his position. Therefore, I don't agree with what the Supreme Court said yesterday, that as when the president declares emergency as part of extraordinary measures, he can suspend a governor. But the same Supreme Court has said that if the Constitution does not provide for something specifically, you cannot add it into the Constitution. This was their 2008 ruling. So therefore, what they declared yesterday contradicts that ruling. That is my main impression of the judgment of yesterday.
All right, thank you very much for breaking that down. Now, for Mr. Jega, a number of people would say that the emergency rule, the measures taken following the emergency rule in Rivers State did not permanently remove the elected governor, that the measure was a temporary action, and as was stated by the lead justice, he says any permanent displacement or abrogation of democratically elected institutions would constitute, that's what would constitute a constitutional aberration. I'd like your take on that. The fact that some might argue that it was just a temporary measure to address the concerns in Rivers State. And for Mr. Nwala, I'd like to ask you, part of that judgment was that the emergency measures must be directed towards, must be temporary, corrective, and proportionate. In your view, was it the president's directive to remove temporarily the governor of Rivers State, the elected governor of Rivers State, was it proportionate to what was happening in Rivers State at the time? Was it corrective in your estimation? I'll start with Mr. Jega, and then Mr. Nwala, you can take on this, the question.
Okay, to say that under the president can temporarily suspend a governor. Again, as I said, the Supreme Court said in 2008 that you cannot add into the Constitution anything that it did not specifically provide. If the Constitution did not provide that a governor can be suspended temporarily under a state of emergency, then it's like the Supreme Court is now adding something into the Constitution that does not exist. Exactly. So I don't think there is a material difference between removing and suspending, because if you don't have the power to remove somebody from a certain office, I don't think you also have the power to suspend that person from the office. And in any case, in 2013, when President Jonathan was about to declare a state of emergency in the 3 northeastern states of Borno, Yobe, and Adamawa, he actually contemplated suspending the governors and the state assemblies. But the House of Representatives at the time reminded him that he didn't have the power to do that, and they will not ratify the proclamation if it included suspending the elected officers. And as we heard recently, the Attorney General of the Federation at the time, Bello Adoke, subscribed to that opinion, which was why President Jonathan declared the state of emergency without suspending the governors. So, as far as I can see, the Supreme Court is now adding into the Constitution something that did not exist previously, against their own stance in 2008 that you cannot do so.
All right, okay. Very quickly, Mr. Nwala, I'd like you to respond to that question. And perhaps maybe to add to that is, according to the calls made by the PDP, should that era be clearly defined by the National Assembly, just so that it's not open to abuse? Just the clarification that Mr. Jega made around suspension, temporary, permanent, or otherwise. What's your take on this? Okay, then let me throw that question to you then, Mr. Jega, just around the PDP's response, safeguarding, ensuring that some of these aspects of the Constitution is not open to interpretation that's vague, making room for abuse. What's your take on that?
Yeah, well, you know, the judgment yesterday said that the Constitution empowers the president to take extraordinary measures when he declares a state of emergency. And it's for him to determine what those extraordinary measures are. I still think the question of suspending elected officials is not provided for in the Constitution, and therefore, according to the Supreme Court judgment of 2008, it should not stand. But those extraordinary measures, they include, for example, suspending constitutional liberties. You know, in societies that value liberty, suspending constitutional freedoms and liberties is a very serious matter, which you cannot do until there is a state of emergency. But you know, here, a police commissioner can announce, because of sanitation or because of a by-election, that people should not come out of their houses until 6 p.m. Ordinarily, you should not be able to do that until there is a declaration of emergency. And then, of course, you can flood the place with security agents in order to restore or maintain law and order. In my own understanding, that is the meaning of extraordinary measures. In any case, you can ask the question, if there is a breakdown of order in a certain state, maybe because of insurgency or something, how does suspending the governor assist in solving that problem. Instead, the federal authorities should come to the aid of the state elected authorities in order to solve the problem. Removing the governor does not serve any purpose in that particular case, as far as I can see.
All right. We'll have Mr. Nwala shortly.
I mean, Mr. Jega, I would like to have you, but I would have loved if Henry Nwala has joined us, because there's a lot of more legal rigor in what I want to talk about here. And Mr. Jega, if you can, espouse some knowledge on it, is this legality of the cause of action at which the Supreme Court nullified the case? And I want to explore legal argument. That's why I said I would have loved if we have Mr. Chetam theory Nwala here, Okay, Mr. Chetam, I want us to explore the argument at the debate at which the Supreme Court did strike out the case by saying the state does not have a cause of action. And I want us to look at some precedents supporting this broader standing on federalism cases, Attorney General of Federation versus Attorney General of Abia States, interpretations of all of this. Does the state that came to Fubara's rescue, do they have cause of action? The Supreme Court said they do not have it. Let's look at antecedents of various cases.
I beg to see, one of the challenges we have seen, it's not even just about the Supreme Court. We have also seen the High Courts also take the same position, which is really sad for our democracy and for us as a people, because what the Supreme Court has done is to streamline those who can bring this particular action. Recall, in that same judgment, the Supreme Court has also stated that they needed to sought leave from the River State government before they could bring that action. But the truth of the matter is this. The Supreme Court also knows that the River State government at the time was no longer Sim Fubara, who was the affected, the victim of the action of Mr. President. Now we had a sole administrator. The sole administrator will know as a fact that the sole administrator will not for any reason issue out such permission to the state governors. So what the Supreme Court has done is to further tie the hands of the people, tie the hands of those who can challenge or various actions of the federal government, and thereby giving the federal government an easy right to their action, which is quite sad, and it's a danger to our democracy, where people can no longer challenge issues that affect the nation and that affects them directly. These governors are likely to be affected by similar actions. So they have a right of a cause of action. But the Supreme Court, in their wisdom, decided and said, no, you cannot come to us. Even when tomorrow the same man can do the same thing to them, and you suspend them, then you will not remind them and tell them that they cannot come to you because they are suspended. Let me tell you this. The Supreme Court has just further created confusion and given the executive arm of government a free ride, which is a danger to our democracy. I must say this categorically, that this particular administration is plunging our democracy into an arena that we may never recover from it as a nation. This is dangerous for democracy, and democracy is currently is being eroded within this particular nation. Something has to be done, because we cannot continue like this. The Supreme Court cannot continue to tie the hands of people from challenging illegality within this particular nation. That should not be done. It should not be seen to be done. We had expected that the Supreme Court will come to the rescue of the average man on the street, come to the rescue of Nigerians. But what we have seen the Supreme Court do with this particular matter is rather unfortunate, and it is sad.
Okay, Mr. Jega, I'm sure you'd like to sound off on it, because in all of this we are saying, the first thing the Supreme Court has said was that there was no cause of action, so there was no basis in the first place. So the case was at first dismissed in the first place before all these arguments that we're now having on the substantive matter. What would you say about that, sir?
You created a cul-de-sac. You said it is only the suspended River State government, it is only the River State government that has the cause of action, and you know that practically the River State government has been suspended and substituted by a military sole administrator who cannot possibly authorize that cause of action. So who else is there? Other state governors are obviously interested in this matter because it can also come to them. The state of emergency could be declared in any other state and the elected governors could be suspended. So do you have to wait until that happens before we seek the clarification of the highest court as to the legality and constitutionality of such an action. So effectively what the Supreme Court did is to say that, okay, once this kind of thing happens, a state of emergency is declared and the state government is suspended, then there is nobody around, practically speaking, who can institute a court action and determine its constitutionality. It's a legal cul-de-sac. That's what they did.
Okay, quickly. Now, jurisdiction is what courts, the judiciary, what they hide under to prove, for technical reasons, we can't say this. Now, we've argued back and forth about how that can be used correctly and also abused. But I would like to ask both of you, have you read the bench judgment by Justice Mohammed Idris, which is the lead judgment, and have you seen the dissenting judgment? Because my own argument is that, look, we should read both and see how the lead judgment is causing confusion, and then we can compare with the dissenting judgment. I have observed that sometimes the dissenting judgment may actually be the more compelling judgment, but we've not seen Justice Obunya's dissenting judgment. Has either of you seen it? Let me start with you again, Nwala.
Well, I have read the 14-page lead judgment as read by my Lord Justice Mohammed Idris, and but that of the dissenting judgment, I don't think is currently in circulation because I have not seen it yet. But every analysis we have given, it's based on the lead judgment, and you see we had a 6-1 judgment in this particular circumstance. It simply means that 6 persons actually reasoned towards the same direction, while we just had one dissenting judgment. So we are just what we are doing is to look at the reasoning of the 6 Supreme Court justices who actually took this particular judgment in this circumstance. But let me also draw our attention to something that. The Supreme Court also, in that same lead judgment, recognizes the fact that the voting pattern at the House of Rep was wrongly done.
Yes.
That the House of Rep did not follow its standing rule or its standing order, and they went ahead to carry out a voice vote for something they were supposed to go by the standing order and divide the House, and people would cast their vote properly. And that simply means that the entire process is flawed. It simply means that the entire process is flawed because the procedure that was followed at the House of Rep was wrong. And the Supreme Court noted that, but the Supreme Court did not say come out open to say the process was flawed. These are the issues. These are the issues because we expect the Supreme Court to be bold enough to come out to take practical decisions on these issues. And it's a challenge. It's a challenge. I really do not know. This has further impeached on the integrity of our judiciary. This whole hanky-panky way of delivering judgment, putting the nation into confusion further. It's a sad situation.
Nwala.
It's a sad situation.
Nwala, in just one sentence, you are convinced that their lordships reached their decision per incuriam. So what is the remedy?
The only remedy I feel we have right now is for the National Assembly to make an amendment to that section 305 of the Constitution and make it very clear and explicit and deal with this particular issue. But unfortunately, the National Assembly we have right now seem to be acting like the puppets of the president. So what we are going to see the National Assembly, we will see them doing it because they are not interested in these things. They are interested in 2027 elections, and that is what their focus is. Whether the nation is burning or not is not their concern.
Thank you. Very quickly, Mahmoud Jega, what do you think about...
I agree.
Yes.
The remedy. Yeah. The remedy is to avoid this confusion by amending the Constitution and make it very clear. And I think the dissenting opinion of the Supreme Court judge, which was, as reported in the newspapers, appeared to me to be at least consistent with earlier positions of the Supreme Court, that yes, the president can declare a state of emergency following the procedures and ratification by the National Assembly, but that does not include the power to suspend elected officials. And I think we ought to amend the Constitution and make that very, very...
All right, okay. Mr. Nwala, let me bring you in. All right. Mr. Nwala, okay, I think we lost connection for a few minutes there, briefly with Mr. Jega in Abuja. But yeah, you can hear me. So I asked the question before you'd lost connection with me earlier today, where I said that in the judgment, Justice Idris had said that emergency measures must be temporary, corrective, and proportionate. In your view, I mean, you're a Rivers man yourself, was the emergency measure by the president to suspend the Rivers State governor elected and the State House of Assembly, was it proportionate?
Well, I must state clearly that the emergency measure was the president was losing grip in Rivers State, and he needed to declare a state of emergency to hold back Rivers State. That was the emergency measure, and he took that particular measure. And if you ask me, by his own calculation, it is succeeding because the governor has defected. It was all about his presidential ambition, nothing more pretentious.
How about,
sometimes we play to the gallery over these issues.
How about the threats to security? Because that's what was the basis of his argument, not about defections. It was about threat to security.
There were never threats to security in Rivers State. Rivers State has been peaceful. Right from the period of the crisis we had, the crisis were merely just talks. There were no actions on ground, no issues. There's currently insecurity in the country, ravaging every part of this nation. Has the president declared state of emergency in those more worse than what we had actually experienced in Rivers State? Has the president declared state of emergency? He has not, and he will not, because he knows that if he does that to the northern states, the northern elites will come after him. Here in Rivers State, we don't have anybody who will actually speak for us and stand for us. That is why the president feels that he can come right over Rivers State and get away with it. The FCT minister is also in league with him. Of course, we saw our brothers supported him, and that is exactly why he is dealing with us as the people. This is what exactly happened in this state, and we all know it. They know this truth. The president, everything the president did was about 2027 and nothing more pretentious.
Simplicity. Thank you, Henry Nwala, because when you look at it, almost every other day we are hearing about kidnapping in Kogi, and the president will declare a state of emergency as regards that. I mean, those are very pressing issues he's not been able to solve. I want to come to you by asking this, Mr. Mahmood. We are in a conundrum. We are in a big problem in this country. Because if the Constitution gives the president a discretionary power, the Constitution will have expected that the person that will sit in the position of the president will have a good sense of judgment and not use the discretionary power of state of emergency for his own political benefit, which is an aberration for the constitutional drafters for the essence of a state of emergency in the first place. And now, the only check and balance that we should have for this unfettered discretionary powers the president is being given is the National Assembly that's a rubber stamp that violated its own standing orders, that could not even probably do a counting and lawmakers writing their name if they are support or not of the state of emergency, but they went ahead to do a voice vote because they are rubber stamp. How do we absolve ourselves from a conundrum where the president is supposed to have discretionary powers, can use it for his own political gains, and the only check and balance, the bulwark we're supposed to have, is already in bed with the president? What do we do?
You are absolutely correct, I think, because that the National Assembly, if the institutions were working very well, the National Assembly will scrutinize the emergency declaration very well. For example, in the case of Rivers State, the audio is poor. It's disturbing me.
Oh, so sorry. Go ahead, sir. We can hear you. Just go ahead, sir.
Okay. For example, a fair scrutiny of the Rivers situation would have said that, look, the main factor in the threat to law and order in Rivers State is the minister of the FCT and not the governor of Rivers State. And the fair and proportionate thing would have been to also suspend the FCT minister and stop him from interfering in the affairs of the state, instead of removing suspending the governor. Now, if the National Assembly were up to its checking responsibilities, I thought that was the position it should have taken. Like in 2013, when President Jonathan brought an emergency declaration to the National Assembly, the House of Representatives in particular stood its ground and said, no, you can do this, but you can't do that. And the president suitably amended the declaration, and he went ahead and declared the emergency without removing the governors of the 3 northeastern states. But this time, the National Assembly merely rubber-stamped the declaration without proper and fair scrutiny. And that is a major institutional failing, which opens the room for abuse of discretionary powers in the future.
Stronger institutions, what we've called for a number of times here on this table. Thank you so much to our guests, both Mr. Chetam, Nwala and Mahmoud Jega. Thank you for your dissecting the issues this morning. I believe that there will still be more opportunities for rigorous conversation around the Supreme Court ruling.